Right. Hi, everyone. Welcome to our August series. Today's webinar is entitled Whether Regular People Can Change or Challenge the Law. Before we begin, a quick introduction about our speaker. Our speaker's name is Thiviya. She's a young lawyer who has completed her pupillage at Messrs. Elvin John and Partners and was thereafter a paralegal while waiting for a call to the bar. She is currently a second-year associate at AJP. She's actively involved in many cases at the firm, ranging from cases in the energy sector, administrative and constitutional law, company law, general litigation, and a tad bit of employment matters. Today, she will be presenting on the remedies available through the judicial review process in the courts. Ladies and gentlemen, without further ado, I'm passing the time over to our speaker today, Thiviya.
Very good evening, everyone. Thank you, Isaac, for the introduction. So I will jump right into my presentation. Can regular people change and or challenge the law? Has anyone actually succeeded in doing so? Next. Just waiting for the slides to come on. Yeah, can we go to the second slide? All right. Okay, so lately, many people have been rather vocal in voicing out their dissatisfaction or disagreement with issues involving the law or public authorities. Most of these complaints are rather channeled into social media rage, or the latest trend also seems to be signing of petitions by the public. But have we really thought about how much of these actions or conduct can actually bring about real changes? Next slide. Of course, public lobbying has been fruitful in the past, for instance, with the Sexual Offences Against Children Act that came into effect in July 2017 after the public outcry for the lack of regulation to tackle the issue of child grooming. Interestingly, this actually began by a group of journalists who were actually working on a project called Predator in My Phone. And this eventually led to so many discoveries and sharing of resources, as well as pulling the MPs to vote on the bill to be passed. Next slide. So today, I will actually be walking you through the remedies in a judicial review process. Many of you are unaware of the judicial mechanism that is in place to keep check and balance between the legislature, executive, and the judiciary. Essentially, this process allows for judicial interference to check on abuse of power, for instance, when public authorities act unlawfully. This is to hold the relevant entities to be accountable for their acts, omission, in increasing transparency in the way that they function, and of course, also in maintaining public interest. Next slide. Okay, so before we dwell into the remedies, I'm very sure everyone is curious if anyone has ever really succeeded in challenging or changing the law. Well, I believe that success rates are always eye-catching, right? So did y'all actually know that in 2013, paintball guns were made illegal in Malaysia pursuant to the Arms Act 1960? Yes, that is true. The police had confiscated airsoft and paintball guns and made it mandatory that such sporting equipment are licensed only to registered operators and clubs. So the possession of the said equipment was to be charged under Section 36, subsection 1 of the Arms Act. Next slide. So in this judicial review proceeding, the applicant, 8 Adventure Sports, had sought declaratory relief from the High Court to declare that paintball markers, pot, and relevant equipment does not fall under the meaning of arm or ammunition under the Arms Act. Therefore, the applicant, 8 Adventure Sports, while they sought for judicial interference in the decision by Minister of Home Affairs and the Chief of Police to declare that the said equipment does not fall under the Arms Act. This was done and challenged through the judicial review process. And guess what? Next slide. The court had indeed found in favor of the applicant and declared that paintball markers do not fall under the definition of arm under Section 2 of the Arms Act. The court also allowed the relief of mandamus against the second respondent to return to the applicant the paintball markers, which were confiscated after verification by expert that certain type of paintball markers must be distinguished from imitation arm under the Section 36, subsection 1. Next slide. Now, I'm sure all of you are wondering, what do these Latin words like mandamus even mean? So what does the weight of a declaratory relief hold? Let's look at some of the reliefs that may sound peculiar to you, but it is actually available through the judicial review process. Next slide. Now, one of the remedies through this process is a declaration. As it goes, it's a binding court order that declares the rights of parties. For instance, a declaration that the relevant government body or public authority should not act in a manner inconsistent with the law as pronounced by the court. Next slide. Now, if you had tuned into the first webinar by my colleague, you would recall that in a dispute between TNB and the state of Malacca, we, acting for the applicant TNB, had sought a declaration from the court that the impugned decision by the Malacca State and PTG to impose charges on utility boxes was indeed inconsistent with the law. Now, moving on. Next relief is a certiorari. It means to be informed of. Now, to illustrate this, I would look back at the previous case that we discussed on the paintball case. The applicant in this case actually had also sought for this relief, whereby they wanted to quash the decision by respondents who confiscated some of the equipment, and also to quash the arrest of one of the employees of the applicant who was present at the premises during the raid by the authorities. However, these orders were not granted by the High Court, as it was found that such conduct of confiscating certain items that were found to be caught under the definition of imitation arm and the arrest were actually consistent with the law. In this case, it must be noted that the High Court judge, based on expert evidence and also findings of fact, had concluded that paintball markers that were a particular type called the Tipman rental. If you realize in the previous slide, there was a picture of the paintball gun of that type, did fall under the imitation arm category, whereas paintball markers which were identified as Spider VS2 do not fall under the category of imitation arm. Hasif, you can go one slide back. Yeah, so this paintball gun is the type of Tipman rental, which still did fall under the imitation arm category. If we can move to slide number 12. Okay, so as we move to the next relief, which is mandamus, that basically means we command. So this is a binding order from court to compel the government body or public authority to do something. So as I mentioned earlier, the court in the paintball case had granted an order of mandamus for the second respondent to return the paintball markers, which were verified by experts, and where court held that that particular type of paintball markers do not fall under the purview of Section 36, subsection 1 as imitation arm, was to be returned to the applicant. So that was the effect of the mandamus order in that case. Now, the interesting part of this relief is that it is only applicable when a legal duty is imposed on an authority. If we can move to the next slide. So in the case of Work On and the Director of Lands and Surveys, Sabah, Justice Richard Malanjum actually explained that an order of mandamus may be issued where the performance or non-performance of a duty has been imposed through a statute. He drew that different principles are applicable if a conduct is as a matter of power or discretion as opposed to a duty imposed by statute. Now, can we move to the next slide? Okay, the next remedy is a prohibitory order. So taking it as literally what it means, It functions to compel the government body or public authority to stop doing something that is inconsistent with the law. Can we move to the next slide? Okay, so I will illustrate an example of the function of a prohibitory order, which we are also referring to the case again of TNB and State of Malacca, in which the applicant TNB sought for prohibitory order from court to prevent the respondents from interfering in any manner in relation to the occupation or installation of feeder pillars and link boxes on state and or reserved land. Yeah, okay. The next relief is Quo Warranto. It comes from the Latin term that means by what warrant or authority. So although this relief is actually rarely sought by applicants in a judicial review, it has been done before. And this relief is aimed to challenge or question one's qualification or authority to hold public office on the ground that he or she is not qualified to do so, or there was a legal flaw in his appointment. Now, the respondent, as you can see in the case of Peguam Negara Malaysia and Dr. Michael J. Kumar, the court in this case had stated that in order to succeed in an application for writ of Quo Warranto, the respondent must actually satisfy 3 preconditions. So firstly, the office in question has been created by written law. The office is a public office and the person proceeded against is not legally or properly qualified to hold office. In this case, the respondent's motion, although it was denied, he was actually challenging the writ of Quo Warranto was against the Director General of the Implementation and Coordination Unit of the Prime Minister's Department. This was with regards to the disbursement and allocation of funds to the members of Parliament. Now, can we move to the next slide? Okay. Last but not least is damages, which is monetary compensation for the losses suffered by the applicant from the aggrieved situation. This is actually provided for under Order 53, Rule 5 of the Rules of Court 2012. And the court may award damages to the applicant if he has included in the statement in support of his application a claim for damages. So this must be distinguished from cost orders, which are usually always at the discretion of the court. And since the nature of judicial reviews are purely based on public interest, where the applicant most likely does not have a direct benefit or will not, and that will not entitle any cost orders to be made against the applicant. So it is standard judicial practice that in cases concerning public interest, there shall be no order as to costs. Right. So that's all from me for my sharing today. I hope that you guys have learned something from today's session. Thank you.
Thank you so much, Thiviya. That was very interesting. And, a lot of us may know about judicial review in theory, or we may have heard about it, but it's very interesting to actually hear it in practice. And I, for one, definitely learned something today. Before we end, we just want to open the floor to some questions. Does anyone have any questions they'd like to ask our speaker, Thiviya?
Hi, yes, I have one question. Being a layman person, how can I actually commence the judicial review process? And if there's any specific timeline to do so? Thank you.
All right, thank you, Kat, for this question. I have to say that what I've discussed today is actually a very small portion of the entire process. And if I may say, it was actually focused on the end goal of initiating a judicial review application. So there are definitely quite a number of requirements before one can actually initiate this proceeding in court. Truth be told, that would actually take an entire webinar session for sure. So if I can run through for you, to summarize it, it begins with the question of assessing whether you are truly an aggrieved party by a decision, conduct, or omission of a public body. Then there is also the test of real and genuine interest in the subject matter. And then moving on to the application of the Wensbury principles. So thereafter, in terms of the procedural requirements, since Kat has asked that when you can actually initiate the judicial review proceedings, right? So according to Order 53, Rules of Court 2012, this places a requirement for an application for judicial review to be filed within 3 months from the date when the grounds to initiate the application had actually arose. So as you can see, there's also a time limit and a time frame from when you can initiate the action. I hope that answers your question, Kat.
Thank you, Thiviya, and thank you, Kat, for that question. We have a question from the floor as well on the chat from Shaira. Shaira asks, Thiviya, were you involved personally in the paintball case?
Oh, okay. Thank you, Ms. Shaira, for that question. Yeah, interestingly enough, yes, I was involved in the paintball case. The case actually happened when I was a final year law student. So in my capacity as an intern, back when I was interning with Mr. Fari Azad, I had a chance to be involved in this case directly. Of course, I did not have a locus as to how a legal practitioner would have a locus. So my work was primarily, in terms of legal work, was more of translation, drafting affidavits, preparing the exhibits where I got to see the layout of the internal gun of the paintball markers and whatnot. Yeah, so I got to also watch brief for the inter partes leave stage for this matter. So yeah, those were my early exposures to the judicial review proceeding. Thank you, Ms. Shaira, for that question.
Thanks, thank you. And you guys now know that our speaker was involved in judicial review from very early on, even as a student. So you have someone that knows what she's talking about. We have another question from Shana. Can judicial review be applicable to the private sector or private bodies?
Okay, so thank you, Ms. Shana, for the question. Under judicial review, the courts can only grant public law remedies provided under paragraph 1 of the schedule to the Court of Judicature Act and also part 2 of the Specific Relief Act. But going back to your question, whether it applies to a private, whether it applies to private sector, there's actually a case that discuss this point. If I can quote, it is, I think, TNB and Tekali prospecting. So in this case, actually, the Court of Appeal held that when activities or decisions of a decision maker in the private sector falls within a public law environment, the same can be subjected to judicial review as well. So basically from this case, the court held that a body that is exercising public function, although from the private sector, for example, like Tenaga Nasional Berhad, is actually can be subjected to judicial review. So it comes down to the nature of the decision or the act or omission or conduct by that body who is exercising public function. Yeah.
Thank you. Thank you for the explanation. Thank you for a very good question. Any more questions? Feel free to unmute yourself or also send it in the chat and I can read it out for you.
Hi, Thiviya. It's Amanda.
Yeah,
I've got one question actually. How difficult is it for a regular person to use the judicial review process?
Okay, thank you, Amanda. I think that's a very valid question. So I would say that this question is interconnected to the question that Kat asked earlier. So as I walked you through the process, right, I would say that a lawyer or a legally trained person definitely plays a very important role here, because the judicial review proceedings must be distinguished from the initiation of a general civil suit in courts, which a plaintiff or a defendant could usually represent himself. So I think here the question comes down to not how difficult it is, but essentially the purpose of reviewing the decision or the powers of certain body and the implications of it. Yeah, so I guess it comes with the having someone who is familiar with the laws to actually represent you and your queries at court. Yeah.
Thanks. Thank you, Thiviya, and thank you, Amanda, for the question as well. Any further questions? All right. One of the participants messaged and said, okay, this question is, what are the benefits of judicial review instead of other popular methods of bringing about change, such as peaceful protesting and petitions?
Okay, so I believe that judicial review mechanism and judicial interference is actually able to bring effective changes in a more systemic manner, because if you realize, it actually sets a precedent and it has a legally binding effect to prevent from similar flaws or abuses from occurring again in the future. But as I stated earlier, it really does come down to the crux of the matter, the nature of the subject matter that is being challenged or reviewed. Because, of course, we don't question the efficacy of peaceful protests or petitions, which have also been proven to bring changes in certain other aspects, such as social and economic policies, or just social norms in general. It's just that through judicial review, it has a legally binding effect. Yeah.
Thanks, Thiviya, and thank you, participant, for asking that very good question. Any further questions? All right. I think that's it then. Thank you so much, everyone, for joining. Thank you, Thiviya, for sharing today. And we hope to see you all at our next webinar happening next week. See you guys and have a good evening.
Thank you.